Well, this story has us asking more questions about what happens to your stuff after you pass. Attorney Theodora Vaporis, partner with Tuggle Duggins, is joining us to help explain. I really think that most people believe that if their spouse dies, that they're going to have access to whatever accounts or money that their spouse had, like, immediately.
So nothing is automatic. If they are the beneficiary on the account, then they can take a death certificate down to the bank and they will be given the money. If they are not the beneficiary, then the probate process has to start. Or if they're just trying to close one account, they can use a process that we have in North Carolina called the year's allowance. So they have to go to the courthouse still, and they have to do an application for a year's allowance, show proof of death and proof of marriage, that they were married to the person. And with that, the court will give them an order for the first $60,000 in assets that the deceased person had. So with that, they certainly could get access to a bank account to the first $60,000. If there's less than that in the account, they could also take a car. So this is good for any personal property. It's not good for real property. But the purpose of the allowance is to make sure that the surviving spouse has access to funds pretty quickly.
Yeah, because I think to myself, so many people get into that position and then they're like, I don't have money to make any of the arrangements because I wasn't on the account. So are there like special words that we have to say, something that we have to say about this form that we need?
It's called a year's allowance. And if they go to the courthouse and they say, my spouse just died and I'm trying to get access to the account, and they have proof of death and proof of marriage, the court will give them that form. And while they don't fill it out for them, they will let them fill it out there and apply. Of course, if they're going through an attorney, the attorney will do that for them and get it filed right away.
All right, now my question is, what about like kids? Their parents pass away, that kind of thing. Can they get access to their accounts like that as well?
Well, there's $10,000 for each minor child that's allowed under the same statute. So the parent or the guardian or the custodian of that child could apply for that.
But I'm talking about an adult kid. So like, you know, you're an adult and your parent passes away and that kind of thing, and you don't have money to bury your parent. You can't access their money to do that.
No, if you're not a beneficiary on the account, you're going to have to go to the courthouse and apply for letters of administration to open the probate, and that's how you would get access. That really can happen pretty quickly in most counties. Guilford's really great about turning that around in a week or so. Unfortunately, some other counties take a lot longer, but most of them are pretty good about turning it around quickly. Funeral homes also tend to be really good about working with families. Somebody has to guarantee it, but they will let you move ahead typically. I shouldn't speak for them, but that's my experience.
Well, I mean, when I think about this and I think about like estate planning, I wonder if people at home are watching this and going, well, they're not the beneficiary, but they'll eventually get it. Is it something where we do need to go to each individual account, whether that's Discover, our bank account, whatever, put a beneficiary on there or put someone's name on there? What's the difference?
Well, of course, that would be the best planning if you intended for your spouse to have that account. Then, of course, the spouse should be on there, and that would just take care of all of this. Oftentimes, though, if you don't have a spouse, you may not want to just put somebody's name on it for them to inherit the account, because if you don't intend for them to have all of it, then you get into that problem, right? If they're all of a sudden, they have all of this money that really wasn't intended for them. So the regular probate route is better for that. So we don't recommend you just throw any name on there, but certainly your spouse.
All right, what is like one of the biggest misconceptions when it comes to like, I've got a will or I don't have a will, or everything's just gonna go to my parents or my kids or my spouse?
Well, last time we were here, you and or I was with you, last time we talked about trusts, and a trust is a great way to handle this, right? Because if your bank accounts are in the trust, or if the trust is the beneficiary of your bank accounts, then your trustee, the person you've named when you die, will have access right away.
And so do you get a trust by going to the bank and putting things in a trust, or do you get a lawyer to put a trust
that you have to
together?
do, or typically you would do through an attorney.
Okay, well, this is all good. And the will is different than a trust, because a trust, it's access right away. The will means it has to go through some
Through the
red
court
tape.
process, correct.
No matter what.
No matter what. So really, if you sit down with an attorney, they should look at your assets and then counsel you on which route is the best route for you. And they should also review your beneficiary designations with you to make sure that there's at least some money accessible. So you might have a small account with the beneficiary, just to take care of some initial things, but not your larger account.
Yeah, and what a gift that is, giving it to the people that you love the most so that they don't have to deal with all of this stuff afterwards
Absolutely.
when they're grieving as well.
Absolutely.
I
Planning
appreciate-
is important.
Yeah, I appreciate your time and expertise as well. If you missed any of this, maybe you need to send it to someone. It's going to be in the Who Wants to Know section of our website. Right now, we're going to get a check on the forecast.